All the best.
Good evening, friends. Today is 1st May, celebrated all over the country and all over the world as a Labor Day. I thank the organizers of Adhivakta Parishad for inviting me to speak and express my views on work to home. Especially when this lecture series is named after Mananiya Dattopant Thengadi. Thengadi ji is the founder of the largest trade union in the country, and I had the honor and privilege to know him personally, and he has been a source of inspiration to me. It is indeed befitting that today, on the Labor Day and Maharashtra Divas, we should debate on an issue that will closely affect a large section of our working population. A few weeks ago, work from home was not a subject of discussion even amongst trade union activists. And most people outside the IT technology industry had not even heard of this phrase. In fact, work from home came into limelight when the Prime Minister referred to it while declaring a 21-day lockout throughout the country. Employers wanted to know whether their employees could work from home, and in fact, some state governments and local bodies directed their employees to also work from home. The concept of distinction between home and workplace is only about 250 years old. The workplace as a place distinct from home came about after the Industrial Revolution, when the center of mass production was set up initially in England and thereafter in other Western countries. This brought about a large-scale change in the social and economic pattern of living. Cities grew with factories at periphery, and the home and the workplace were segregated and become distinct entities. In India, the same pattern as in England was followed as we were under the British rule, with cities surrounding the industrial establishment. And naturally, as a corollary, what followed was the laws relating to employment. In India, the industrial laws were enacted sometime after independence. And if we look at any of the laws, we find them to be establishment-centric. Right from the contract of employment, rules of conduct and discipline, or even the social security laws have all stated that working in the establishment is a prerequisite to the benefits. The whole country has been working at the place of establishment and has been living separately, and the work, home and establishment have remained separate and segregated. Later on, despite the development of many other technologies like the internal combustion engine, the steam engine, this fundamental pattern of working in an establishment did not change. Persons were employed for wages to fulfill the object of the establishment. But then, in the early 70s, a major development happened. Analog technology was replaced by digital technology. Mechanical and electrical process were replaced by electronics, and new avenues of employment were discovered. However, even then, the employment remained establishment-centric and the workplace still remained separate from home. The most dramatic change has come about in the last 20 to 25 years with the internet, what could be called as an internet revolution. The internet, with its high-speed computing technology and data processing and data management, has changed the method of communication and working. What basically changed was not just changes in the workplace as it had happened during the digital technology, but what has changed is the place of work itself. Due to high-speed communication, computing capacity, and storage capacity, it was realized that the place of work need not be static and unchanging. Through virtual personal network, VPN, computing and storing data could be done remotely and the place became irrelevant. With the introduction of internet, remote working had become possible and had become a norm. This remote working, right from the back office and computing jobs, brought back office and computing jobs to India, and several companies set up establishments to cater to their international clients and provide services through the internet. The place of business or place of work had ceased to matter, and it had become completely mobile. Some IT companies encouraged their employees to work from home to save establishment costs or to cater to the clients where the time zone was different. These constituted only about 10 to 15% of the IT company's workforce. However, beyond the IT company, this concept has not caught the imagination of the employers. However, today, the time has seriously come to consider the concept of work from home. Every great crisis, like war or pandemic, changes the way in which we do our business and we live our lives. Today, there are, in fact, two triggers which compel us to consider the possibilities of enforcing and implementing work from home. The first trigger is obviously the corona pandemic. Its global impact and the lockdown it has ensured. Its global impact and lockdown and their extensions which we can expect in the near future. The second trigger is a very real fear of huge economic slowdown with all its devastating consequences like loss of jobs, cost-cutting measures by the employers, scarcity of commodities, rising prices, and finding the right type of employees to do the work. Therefore, we need to examine the concept of work from home from various angles. Legally, the arguments are these. I have already pointed out that our laws are establishment-centric. Contract of employment envisages working at various locations of the employer, but none envisage working from home. There are notional extensions of workplace. For example, a bus driver or a conductor, for them the bus is a notional extension of place of employment. Similarly, a salesman working in the field, the area of work is a notional extension of his workplace. In most contracts of employment, especially in the IT sector, an employee could be required to work from client's premises or any other designated premises as per the requirement. The places envisaged under such contract are places over which the employer has a control, either physical or contractual. What I mean is that the client of an employer has permitted his employees to work from his or his client's premises. The words as per the requirement in the contract of employment is required to be considered from the perspective that what is the place of that the place of work would be under the control and supervision of the employer himself. It would be a complete misreading of a contract if it were intended or if it were interpreted to mean that an employee could be directed to work from home. The employer cannot be said, even impliedly, to have control of home of an employee. In my view, at present, the employment contracts are still establishment centric, and an order to an employee to work from home would not be with authority of law. At this stage, I think it is necessary to distinguish between work from home and work at home. Work at home is the additional work that an employee voluntarily performs to keep pace with his duties at the establishment and is not a substitute for working at the establishment. Even there, whether an employer could legitimately direct an employee to complete his work at home is doubtful. Looking at this from another perspective and angle, if an employee were to refuse to work from home, could an employer maintain any disciplinary action against such an employee? If the present rules of discipline and conduct are to be read, it would be difficult to successfully maintain any disciplinary action. Misconducts enumerated in the rules of discipline and establishment are establishment centric, and the employers do not have a cause of action against an employee beyond his place of work. It is well settled that a conduct at certain places could also be scrutinized, provided that it constitutes a notional extension of workplace. The law on this issue is today well settled, and only where there is a notional extension of workplace could an employer initiate disciplinary action against an employee. Another aspect is whether an employee could deny wages to an employee. To my mind, if that is the only defense only defense in support of denial of wages, it would be difficult to sustain such an argument. Even on the principle of no work, no pay, denial of wages for refusing to work from home would be untenable, as the work from home would not be a legitimate order for want of authority. Therefore, under the present employment, the directives to work from home is not an enforceable right. There is another angle in the matter which is required to be considered. That is right to privacy. There is an old English saying that an Englishman's house is his castle, meaning that people have a right to do what they want in their own homes, and other people or the state has no right to interfere with people's private lives. This in England is a common law right. In America, it is found in the Bill of Rights and is implemented by way of Fourth Amendment to the US Constitution. In India, the right to privacy has been put on an equal footing as a fundamental right. While interpreting Article 21 of the Constitution of India and expanding its ambit, the Supreme Court relied upon Article 12 of the UN Declaration of Human Rights. Article 12 of UN Declaration of Human Rights reads thus, and I quote, "No person shall be subject to arbitrary interference with his privacy, family and home." The Government of India has accepted the UN Charter for Human Rights, and the the provisions of privacy within the homes is required to be considered as a part of the Indian laws. It is thus extremely doubtful whether an employer could insist on an employee working from home. Now, apart from these issues, there are several other issues that are required to be considered. They are legal issues, they are real issues, and they are required to be answered before an employee could be directed to work from home. The list of such issues which immediately come to my mind can be as follows. Number one, would an employee's residence be treated as a notional extension of an employer's establishment for him to maintain an order of or direction to work from home? If the answer is yes, then would such a residential premises be considered as a commercial establishment, attracting the commercial property taxes and commercial rates for the electricity? Could a residential society or a building be converted into a commercial premises merely because an employer wants his employee to work from his premises? How would number two, how would hours of rest and hours of work be separated and implemented? Number three, could a residential premises be used only because could be used for commercial activities merely because one employee would want to be is required to work from home? Another aspect is that would an employer be able to implement a an attire code for an employee when he is directed to work from home? And finally, what is also relevant and very important is that who would be responsible for the data security? Would an employee be responsible for data security, or would the employer take care of the data security that is subject to hacking or breach? So legally speaking, if the existing laws are considered as they clearly do not support work from home. Therefore, considering the present crisis of corona pandemic as well as the fears of economic slowdown or a shutdown, we need to consider new laws, guidelines and protocols if we have to implement work from home. What is also required is to recognize the need to consider social and psychological aspects of work from home. Social issues are serious in our family-based social lives and our small and crowded houses. Our family members cannot be made hostages. Loss to one person working from a house. The children cannot be prevented from playing in the house, or the wife cannot be prevented from listening to her music if an employee is to work from home. These social aspects have consequences in a family life, especially in the Indian context, are required to be studied and considered before any guidelines or protocol are enacted in that regard. Similarly, it is also necessary to consider the psychological aspects of a person working from home. Today, team building and working from home, team building is an essential component for social connection. However, social interaction, loss of social interaction, loneliness and anxiety can lead to a serious crisis when an employee is required to continuously work from home as a part of his active working life. Let us not forget that there will be several persons who would welcome and support the concept of work from home, such as women. single parents, couples with very young children, where both husband and wife are working, the disabled, they would be reasonable, they would give reasons like saving time on commuting, traveling, being able to look after their children, etc., to work from home. If the employees are willing to work from home and the work from home is voluntary, we are not considering those aspects of the matter at this stage. Employers can also argue that in favor of work from home, saving the cost on establishments and overheads. For example, TSCS has already announced that for the next 2 years, 40% of their staff would be working from home. In conclusion, let me say that implementation of work from home is far too complex to be done in haste. It will have far-reaching consequences legally, socially, and psychologically. What is needed, therefore, is a wider debate from all stakeholders, employers, employees, social scientists, economists, and legal fraternity and trade unions, a debate which should be realistic, forward-looking, holistic, and balanced. Without such a debate, and without new protocols and laws in place, let us not jump on the bandwagon of work from home. Once again, I would like to thank you for giving me an opportunity for sharing my thoughts. I would welcome comments and interaction. Thank you very much. There is a question from one of the viewers, if an employee is treated as notional extension, if a house is treated as a notional extension, then any accident which takes place during the course of employment would attract compensation from an employer. I think you are very right. This a Workmen's Compensation Act would be applicable to a place of employment. And if an employee is required to work from home, then the accident which has occurred would be during the course of employment and arising out of employment. And such an accident would attract workmen's compensation. This is a matter which requires further consideration, in the sense that whether getting a mail would amount to work from home or a requirement to work from home. This aspect has not at all been a part of our employment laws as on today, and it would certainly be a breach of privacy laws if a person is required to answer a series of mails by an employer when he's beyond his working hours. There is one more aspect in perspective of the earlier question. In France, a person who is a gig worker, for example, a person who is a driver of an Ola company or a delivery boy of a Zomato company, is considered as an employee and not as an independent contractor of of the aggregator. It would be difficult to cause of work from home, because the question that would arise is whether such a right exists in an employer merely because it forms a part of the contract. I would refer to the judgment of Central Inland Water Supply, where the Supreme Court said that a contract between a sheep and a lamb is required to be looked in from the perspective of employment. So far as Mr. Mishra, the question that would really arise is, ask an employee to complete an assignment or do an assignment sitting at home. That is work from home, and that is today not envisaged in the contract of employment. Work from home, the coronavirus pandemic, it appears to be a new idea that has emerged. The litigation that would arise out of work from home, as far as litigation is concerned, the areas of litigation would be where an employer would want to put the work from home as a condition of employment, or he asks an employee.
Quite a few questions.
No employer can continuously monitor the work of an employee. Therefore, the target of completing particular must be given, rather counting hours of work. Now, what is the question, please? Even today, without work from home, there are something called productivity norms. But these productivity norms are required to be worked on the basis of an 8-hour shift. You cannot have productivity norms which do not meet the working hours of an employee. So similarly, if a task is to be given to an employee, then that task must be within the working hours that are prescribed under the Shops and Establishment Act or under the Factories Act. So far as timing of work is concerned, once an employee is required to work from home, it would be difficult to monitor his hours of work and hours of rest. Employee cannot be told to work indefinitely while working from home. If there is no work, then question of working at home would not arise. A layoff would be granted to an employee on the basis of the reasons which are permitted under the industrial law. And if merely because there is no work, a layoff would not be permitted, and work from home is not a solution for layoff. No, this is a complete misnomer or a misunderstanding of the laws that a person is required. There are no normal working hours in the IT company. The IT companies very much form a part of an establishment laws that are laws of shops and establishment, and a person is required to work as per the limits prescribed under the Shop and Establishment Act. The IT companies which work beyond this are required, according to me, are liable to pay overtime wages for their employees. It is not project related, but it is hours of work related employment. If, if, it, if the In such a situation, it would be an illegal termination, or it would not be a disobedience of a lawful order, because an employer cannot legitimately tell a workman to work from home. Whether his family members permit him or not would not be relevant. What would be relevant as far as the employment laws is concerned is whether an employer has a right to take action on the for refusing to work at home, or his inability to work from home. I have already stated that no work, no wages policy should not apply to work from home, because there is no right of an employer to ask somebody to work from home. To apply the principle of no work from no pay, there must be refusal on the part of a workman to do work at the place of employment, not from his residence. According to me, the work from home is going to take a different look, whether it is government agencies, local authorities, or private employees. The question that would arise is whether work from home would be advisable, and whether there is necessary protocol and rules and laws put in place before a person can be advised to work from home. Kindly consider a case where an employee is required to work from home, living in a one-room chawl, along with another 6 members of his family. How does he work from home? How would he be able to fulfill his contract of his obligations in the house? So therefore, if an employer wants somebody to work from home, I think he will have to provide for necessary place within his house for him to work. Okay, thank you very much. I'll finish this seminar. Thank you.